If you are legally liable anytime that you do not exercise the care that a reasonably prudent person would exercise under those circumstances, isn't it kind of like a perfection standard? You have to be reasonably prudent and careful all the time. You can't reach over and stop your kid from spilling the coffee or the hamburger or whatever, or fighting with his brother or sister. Hey, you can't answer your phone anymore unless you have Bluetooth, and even then, be careful. There are a whole bunch of things that you can't do because they are, and you can't hit somebody from behind because that's going to be assumed to be negligent. So there are a lot of things you can't do. Hey, can you cut into somebody else's lane, and if they hit you from behind, it's their fault? Maybe yes, maybe no. Depends on if there are witnesses and if they favored you or favor them. Police reports don't help much. They don't tell you much about how accidents really happened because they didn't see it, they didn't get there, and they've heard two different stories, and they don't know who to believe, and they don't really care. In fact, what the police would usually like to do is to fill out the minor damage under $300, one-page report, gives names, addresses, and insurance companies, and go away. They don't want to have to do an investigation. If there's a death, then they're out there for hours and hours and hours and hours investigating, and they do measurements and photos, and it's like, there used to be a song many, many years ago called Alice's Restaurant where they did all that stuff. And they do that. But usually they don't. Usually they don't do very much. They just talk to the people quickly, exchange insurance information, call the ambulance if somebody's hurt, and then leave. Okay, so what are the kinds of torts? First of all, torts are different than contract. Contracts usually protect property and businesses and money. Torts hold people responsible for negligent or intentional injury to persons or property, even if there's no contract there. If I fall asleep at the wheel and I crash into Brandis's garage and I damage the property, that's a tort duty, that's a tort responsibility. I don't have any contract with her that I won't damage her garage, but I did. So I paid for it, my insurance company pays for it, because the tort law says if you are negligent and you cause damage to person or property, you are legally liable for it. Okay. Intentional torts, the difference between intentional and negligent is basically if you intended to do what you did, if you intended to cause the harm, or if you did something that you could easily expect would cause harm, that was foreseeable, that's called an intentional tort. So if you bang your car into somebody on purpose, that's an intentional tort. If you're driving drunk and you're really careless, there's a line in there where it's called grossly negligent, where you're reckless and careless, willful and wanton, and all of these legal words. Somebody asked me one time, how come the law uses all these little special words and stuff? Why don't they just use plain English? And another friend who was a 25-year lawyer said, well, then what would you need lawyers for? So, in fact, in the law, we don't even call jargon jargon. We call it terms of art. So I was taking the deposition of a psychologist, and he said, oh, we have more jargon than anybody. I said, no, you don't, because we even have a word for jargon. We don't even call it jargon. It's terms of art. He said, okay, I give up, you win. And, or you can have a situation where maybe you're in an auto accident case and your client is in there testifying about how the accident happened, and he doesn't think it's his fault, he thinks it's the other guy's fault. But in his giving his testimony, he says, well, maybe I was a little bit negligent, at which point his lawyer shrivels up into a little ball. Oh no, you use the magic word, negligent. Can't say that. You could say, well, maybe I wasn't perfect, that's okay. But if you say I was negligent, then you're in trouble, because that's a magic word in the law. Okay. Battery is one kind of intentional tort. It has nothing to do with little mechanical rabbits. What do you understand battery to be?
Is it lawful touching or hitting or injury of another person?
Okay. got the word assault, and when we think of assault, that's what we think of, right? That you're hitting or hurting somebody physically. But legally, assault is less than that. Legally, assault is putting someone in fear of imminent bodily harm. So maybe you didn't touch them, but you still assaulted them because you held a gun and pointed it and said, I'm going to shoot you. Or you threatened to punch them and they thought you were going to do it. Or you aimed a kickbox kick at them and you missed them, but you intended to put them in fear of physical harm. So that's the distinction between battery and assault. Where you see battery, and you almost never see those words in tort cases now, you see them in criminal cases. But where you sometimes see one of the things that came out of the concept of battery is in medical malpractice cases, if the doctor did not get a proper informed consent from the patient, that tort comes out of the old theory of battery, where you have an unlawful or offensive or harmful touching. Because if the patient did not give a fully informed consent as required by law, then that operation, that surgery, whatever the doctor did, was not a lawful touching. And the doctor can be liable even if the surgery did not violate the standard of care, if they didn't have informed consent. They can also be liable if the surgery fell below the standard of care that a reasonably prudent specialist would have exercised in similar circumstances. So there's two ways for doctors to get hit with torts. One is informed consent, and dentists, and the other is fall below the standard of care. But that's not enough to do it. If you prove that the doctor malpracticed, that doesn't necessarily make you the winner. You also have to prove that the malpractice caused the harm. And when we think of it, say, oh, well, if you screwed up the surgery, of course it caused the harm. What else? Not so simple. A lot of people who are surgical patients have all kinds of medical problems. A lot of them have surgeries that may or may not have guaranteed success or high probabilities of success. And so there are many medical malpractice cases where the doctor is not determined to be liable, even if the doctor fell below the standard of care, the surgery was not up to the standard of care that should have been exercised, because the victim's lawyer has not proven to the jury that that malpractice caused the harm that they're complaining about. Example, a cancer patient has surgery, it's unsuccessful, they prove that the surgery was below the standard of care, but the doctor for the insurance company comes in and says, would have died anyway, very, very low chance of success, 80% chance the surgery is not going to save him. Okay? No causation, no damages, no liability. So in all tort cases, you have to prove both negligence or intentional conduct and causation of resulting harm. Those are the two essential elements of every tort case. Third kind of tort they got down here, false imprisonment. It doesn't mean that some guy, the dog Chapman goes out there and grabs you and throws you in jail, and you say, wait,